we found another post-ACA law about Section 1411. I didn't know it existed until we did some further research. In October of 2013, Congress passed an appropriations bill, signed into law, for 2014. And there's this little paragraph in there that says that HHS shall not issue subsidies on the exchange until it has certified to Congress that it has stood up the due process required under Section 1411.
And that's in the law?
That's the law.
Welcome to the Benefits Insider. I'm your host, Chris Hamilton, and today we're going to do something a little bit different. We're going to talk about a news story, which I think is going to be probably one of the biggest news stories in employee benefits in 2025, and virtually nobody is talking about it until now. I'm excited to cover this with my special guest, David LeFevre, or is it LeFevre?
It is LeFevre.
Okay, so I just want to start off by saying we've been friends, we've worked together for over 10 years.
Yeah.
And it wasn't until recently I realized I was mispronouncing your name. It was actually Siri that corrected me.
Yes.
When I hollered out to Siri to give you a call and she pronounced it LeFevre. And I think that was my first question when you answered the phone.
Yes.
Is your name LeFevre?
Yes.
And you said, yes, it was.
Yes, it is.
Okay. Well, David LeFevre is the managing attorney of LeFevre Law PC, and he's the founder of Erisifier Benefits Compliance Solutions. And they work with employers nationally to help maintain compliance with the laundry list, an ever-growing list of employee benefits laws and regulations, working with multi-employer plans, unions, governmental entities, and employers of all sizes nationally. Now, I'm really excited for this conversation today because it's really the big thing that we're going to discuss is going to have potentially seismic implications for employers, specifically around the Affordable Care Act. And I'm really looking forward to having that conversation. It's a David versus Goliath story. So whether somebody's a CEO, an owner, CFO, or HR leader, this is going to have big implications both financially and benefits-wise. You know, the goal of the Benefits Insider podcast, and really what I'm trying to do with this content is, one, helping expose misaligned incentives, conflicts of interests that cause employers and employees to spend more on health insurance than they should, and most importantly, what they should be doing to solve that problem to create more financially sustainable benefits, offer better benefits to their employees. And so I'm gonna have to start this off with somewhat of a confession.
All right.
You know, anybody that's seen my content in the past, I don't really cover compliance. Not because it's not important, it's unbelievably important. It's just not one of those topics where you really have an opportunity to dive in and affect the financial piece of somebody's benefit package or enhancing the benefits.
Not until you get penalized or taken to court or otherwise that theoretical risk made real.
That's right.
But you're right.
But the topic for today, it really does have what I believe, just based on our prior conversations, this is going to have such a big financial impact to businesses, and it's going to affect benefit design potentially, and perhaps it could have, ability to have some creativity with benefits down the road. We can discuss that kind of further on, but before we jump into that big case, that's the real big topic for today. Is like what's going on with the ACA? It's been challenged a number of times unsuccessfully. This is going to be different when you think about brokers and consultants. The role that we play now versus 10, 15, 20 years ago, it's so drastically changed. Yep. Our clients count on us to handle so many different things aside. I would say back in the day, the brokerage and placement of insurance was 90% of the job, and I would say it's almost 10% of the job now. When you start thinking about just all of the consulting work, compliance, wellness,
tax,
care navigation, the actual design of health plans. And it's really hard for one or two people to be experts in all of those. It's almost impossible. So we rely on pharmacy consultants and medical directors and attorneys and, so many subspecialties that we have to bring in. And when you look at the business model of a lot of the national firms, they bring people in-house. But a point that you made that I think is really interesting to highlight, and it's one of the reasons why we love working with you, with our clients, is there's a very distinct difference between somebody that actually practices law meaning you are on the front lines. You have to litigate cases. You have to represent employers in court or pre-court. You're making the case. I call it sharp you're fighting with a sharp sword in the field, versus somebody that just works in-house and can pontificate but can't actually give legal advice.
Right.
And that's oftentimes, just as a side point, when you talk about the RFP process and companies that are looking to hire a brokerage, they're looking for, do we have in-house counsel? How valuable is that in-house counsel to you when you need counsel? I think is debatable, which is why at Hotchkiss we've opted not to bring somebody in-house. We hire the best and brightest that's in the marketplace that has a sharp sword, that's out in the field litigating, representing clients, because one, you have the ability to represent clients directly, and two, you have direct experience in what you're preaching. So it's not only can I read the law and understand what it's saying, I've actually put it to application in the field, in the practice of law, which in my experience in the last decade is the difference between success and failure, in my opinion.
So let me comment on that just real quick. So the RFP question is, I'm sure it's from a template. When you're conducting an RFP as an employer, it's like hiring like an individual to fill a position. You've got plenty of applicants, although the number of applicants or the number of brokers is rapidly consolidating, but you still have a decently long list, and it takes time to get through them, and so you need to put them through some sort of sieve in order to sift through them and figure out who's got what. And I think that's one of those questions that, do you have in-house ERISA counsel questions on RFPs, that is kind of it's an indirect, inefficient, but well, I wouldn't say inefficient, but it's an indirect way of getting at, do you know what you're doing kind of thing. Yeah. And I would highly encourage employers not to rephrase that question, because simply having in-house counsel doesn't mean anything. We work with quite a few insurance agencies who do have in-house ERISA counsel. Some are better than others. The best in-house ERISA counsel we've worked with are they're good general counsel in a sense, that they do more traffic cop kind of work. Like, okay, this is the easy block and tackle, this is the answer to the question, and no, the client needs to engage somebody for this kind of thing. Those are the really good in-house counsel, when they know the limits of what it is that a consultant really ought to be doing. And instead of having that question of, do you have in-house ERISA counsel, I would encourage employers to put on the RFP a more of an open-ended question about how you handle matters of ERISA compliance, and see what you get. Because the answers are going to go one of two ways. The brokers are either going to answer with, we have all these shiny baubles, and it'll be plain to the employer that they are shiny baubles, right? I get this news service. I've got this, software platform that spits out stuff, right? Yeah. Or the employer will, which may be what they want, right? Okay. Being a consultant and a lawyer, my preference is clear, obviously, but if you want the shiny baubles, that's perfectly fine. The other form of that answer will be more of a consultative, approach, that we work with the employers for these kinds of issues and bring in the best of the best on this, and here are the names of the folks that we work with, and right. And then you got your short list, your Rolodex over there, and the employer will see, okay, shiny baubles versus high-powered consultant. Yeah, and that kind of question will get the right answer on your RFP. So
I'll just give you kind of my hot take on RFPs. I think they're a complete waste of time for most employers, because they don't get the result that they really want. And I'll give you an example of what I mean. RFPs turn into a beauty contest. So when you send an RFP out, a brokerage receives it. It's typically not the consulting team that's answering those questions. They kick it off to a marketing department who is pulling canned answers. And I recently picked up a large multi-state, almost national type account that you actually work with us on. And I did go through an RFP process with them, and we did ultimately win that case. And the group was gracious enough to share samples of what they received, because they just thought it was highly inefficient after the process was done. And they had said, we'd asked for these to be consolidated down to 25 pages, whatnot, of responses, that's a pretty big RFP. But
Yeah.
the big national firms that we were competing against, with their appendices and exhibits, it was, one of them was almost 200 pages.
Yeah. In the old days, it'd be a binder, like an entire 3-inch binder.
Ain't nobody got time to read all that. And
nobody.
they told me they didn't read all that. And what it was is, this is how big we are. This is all the resources that we have. But you know what that company's number one, and this is by far what I see just consulting with employers nationally, is the number one problem they're trying to solve is they want to see an alternative, and they want to see strategies that help them reduce the cost of their health insurance for the company and for their employees. And they want to be compliant, obviously, in doing so. But because of the ACA has been in place now and in force for 10, 11 years for everybody, the increasing in cost has become unsustainable. Right. It's a breaking point for most mid-market employers now.
It's going to become a breaking point for the country.
Oh, it already is. If you look at just aside from employer-sponsored healthcare, which is the largest sponsorship of health insurance nationally, you just look at what Medicare and Medicaid has done to the national budget over the last 10 years. It's the largest.
That's peanuts. So, did you know that the single largest federal budget line item is the tax giveaway for health and welfare and retirement benefits?
Tell me more.
So the federal budget.
You're talking about what they forego in taxes because of the tax break.
It's a negative revenue item, and it's in the budget. So the federal budget, which you can get a copy of, has you got defense spending, you've got entitlements, you've got various and sundry other things that barely amount to a hill of beans. The single largest item in the federal budget is the negative revenue, the loss of tax revenue from making health and welfare and retirement benefits non-taxable. Single largest item. The one that's growing way, way faster than the other is health and welfare, because the measure of the tax giveaway is the premium.
That's right, and it's growing so fast.
And the premiums are growing because costs are increasing, and nothing is stopping it. It's outpacing inflation. It's outpacing every measure of responsible spending you can think of. It's outpacing everything. And it has gotten both parties' attention.
Well, it's going to be hard to undo that. And I think it highlights unintended consequences of actions taken by the government, because you hear this wave rising on social media. The government needs to intervene. Well, the government has intervened numerous times in healthcare and insurance over the last couple of generations. I mean, you start talking about that tax giveaway here. Right. That goes all the way back into the 40s. Yep. What was the government doing back in the 40s? There were wage controls, exorbitant tax rates on the marginal. I mean, upwards of 75 to 90% marginal tax. And so as an employer, how do I attract and retain talent? I can't really pay somebody more. Even if I could, they're not going to get to keep it because the government's going to tax it. That's where the government comes out with this tax incentive you can write off the health and retirement, health insurance costs. Yep. So now I'm giving you compensation that's not taxed. Right. And I get a benefit as an employer for doing it. Fast forward 80 years, now look at the impact, which I think is pretty interesting to see. The other one that I talk about all the time when you start talking about unintended consequences of the government action is medical loss ratio rebate in fully insured plans. So you think about that one. Okay, what's the carrier's incentive? Basically, the medical loss ratio rebate is the carrier's profit margins are capped for large employers. That's if you have more than 50 employees at 15%. So if they take in $100, they've got to spend $85
on claims.
Claims. Okay, so if you're the CFO and CEO of a publicly traded health insurance company, do you want to make 15% of $1 billion or 15% of $1 trillion? So immediately out of the gate, while it was well-intentioned, it created this perverse incentive that health insurance companies now want premiums to escalate as fast as possible. But the secondary effect that had, right, because I think the private market is a lot faster and smarter than the government, is if you look at what these health insurance companies have done, they've vertically integrated and consolidated. First thing they did is they consolidated. They bought up all the other insurance companies, and so where we used to have 20 insurance companies, there's now 4 big ones. And then what they did is they integrated, meaning they own pharmacy benefit managers, they own physicians, they own clinics, distribution of specialty, the most high cost medications, and they profit from each one of those verticals. That doesn't count against their 15% profitability. So they can overcharge themselves and show a loss at the insurance company level, but they've captured profitability. That's where I start talking about with the benefits insider, misaligned incentives, and the conflicts of interest that cause employers to pay more than they should. And so when we start talking about government intervention, it often doesn't have the while it's got good intent, it doesn't have the outcome that we expect, and that's a whole separate conversation.
Well, yeah. So, end game that. Like, so where does it end? What happens?
Are you asking me for my opinion?
Yeah.
I think the very first thing we've done this in our past. So what I'm about to say is like is going to be controversial and unpopular, but it's what we need for the betterment of our society. Because if you think about healthcare and insurance, it's everybody needs access to healthcare. Everybody needs a way to pay for it, and it needs to be affordable. We spend more on healthcare in this country than
any other developed nation.
That's right, and we have worse outcomes.
Yep.
And so the very first thing that we need to do is we need to break up legislatively those conflicts of interest. So if you're a big health insurance company, we need to break those up, similar to what we did with the Bell communication system back in the 80s.
Yeah.
Think about the baby bells. You know, we had a monopoly, essentially, is what we had. And that's what we have in health insurance today and healthcare today. You look at some of the insurance companies, they're the largest, several of them are the largest employers of physicians nationally. They employ more doctors than, add up all the hospitals that we have, the big ones in Houston, Austin, Dallas, Fort Worth.
Do you see that happening, though? Like, I mean, that's.
I think there's enough pressure now. I think there's enough. I think you see a groundswell. I mean, especially with the recent shooting of the UnitedHealthcare CEO. If you just look at the response that we've seen on social media, praise for the shooter.
Yeah.
And while I can understand why people are upset, health insurance is one, it's expensive, and two, there's so much friction in the way that it gets used. But the way that it's being adjudicated by the carriers is dictated by their incentive model. And the very first step is breaking up the insurance conglomerates, if you will. And it can be parceling out, you can't own a PBM anymore, or we put limits on what they can and can't own, the interactions that those companies have to have with themselves. It really is, it's no longer independent. It's no longer independent.
I've gotten rather cynical on the ability of Congress to do much. And that's a, you know, I mean, you're talking about, you know, breakup of extremely large, extremely powerful companies, and I don't have the faith that that'll actually happen.
Well, I share the same sentiment. I mean, and I've talked about this a lot. If you look at the lobbying dollars that are spent in Washington, healthcare is over 2.5 times. So when I talk about healthcare and insurance, you're talking about big insurance companies, the hospital lobby, the big pharma, physician groups. It's more than 2.5 times. What is 2.5 times the size of oil and gas and defense combined, and that's public data.
Wow.
And over the last 10 years, there's been over $6 billion spent in Washington lobbying. So if you think about $6 billion over 10 years, if somebody wanted to change, we'd be able to get that with that amount of money and that amount of time. Yet we see this problem exacerbating every single year. And so it tells me they're not lobbying for change, they're lobbying more for their
100%. 100%. So in October, there's a gathering of health and welfare ERISA geeks. And one of the things that the American Bar Association does is they bring in a couple of lobbyists and kind of talk about what's going on. This last October, the lobbyist presenters made the same point that you did, that everyone is lobbying for the status quo. Everybody. At least on the federal level. So you've got some stuff going on the state level with PBM regulation that is going to be really interesting, kind of hinging on a United States Supreme Court decision about whether states can even regulate PBMs. So that'll be really interesting, and we should see that case in 2025. But aside from that, everybody in Washington appears to be lobbying for the status quo. Just keep it going the way that it is. But the other thing that's happening is there are some folks on both sides of the aisle that are looking at the kind of very unsustainable nature of the tax side, the revenue side. They're looking at, the federal budget, and we're dealing with monopoly money nowadays because money is not real. But there are some folks who are like, this is not sustainable as a country at all. And my mentioning that the single largest federal budget line item is health and welfare and retirement. Retirement used to be the thing that Congress would talk about the most. So Secure 1.0, Secure 2.0, there is a Secure 3.0 in the mix. Retirement savings, the decline of Social Security as the primary retirement vehicle. And so that retirement has generally dominated the congressional conversation. But post ACA, health and welfare has really taken front and center because it is outpacing the retirement side in terms of the federal expenditures, the loss of revenue. And some Congress folks are starting to realize that it is a runaway train, and that if costs do not come down, that federal budget line item is only going to get bigger and bigger and bigger. And the rate of inflation is higher than inflation as a country. And so it's just going to balloon.
Yeah.
So one of the things I've heard that was really interesting was that on the Republican side of the aisle, there is a proposal that is being taken seriously to cap the amount of value that can be non-taxed to the employee.
Almost like what's been done with mortgage interest deductions.
The SALT tax and mortgage, yes, absolutely, right? And so take a stab at the dollar amount per year that would be limited as non-taxable
in aggregate
income.
or just per person?
Per person, per year.
Well, I mean, if you think about just on average, it's about $12,000 to $15,000.
You're super close. So they're gonna peg it at 12. So the proposal is to peg the maximum tax giveaway at $12,000. Now, what does that sound like? If you change the marketing on it, it's the Cadillac tax.
Oh.
It's the inverse.
Talk about a blast from the past.
It's the inverse of the Cadillac tax. The Cadillac tax, typical progressive Democrat, right? You tax something extra. But the Republicans took the same exact proposal, just flipped the script, and just made anything in excess of a certain amount not subject to the non-taxation, therefore making it taxable. So it's not a Cadillac tax. All we're doing is limiting. Anyway, so it's different marketing, but it's the same principle.
But make no mistake, that is going to affect every employer nationally. Because if you look back over the last 20 years at the inflation rate of health insurance and healthcare services, by far, it is the most inflationary item in our economy.
Yep.
Now you might say oil and gas, well, it might fluctuate up. We might go to $100 a barrel oil, but then it comes back down to 50.
Right.
But if you track it sustainably over time, by far, by a factor of 2 to 4 times, healthcare is more than anything else in our economy. And so if you,
even just for my tiny little firm, you're talking about 10, 11% increases every single year.
Yeah.
That's a doubling every 9 years.
Yeah.
A doubling. And it's a large line item for our payroll. But anyway, I digress.
Well, when you think about, particularly with the affordability and the employer mandate, which I think really ties into the big topic of today. So take that potential tax on plans that cost more than $12,000. You take that inflation rate, run it out ahead, just about everybody's going to be spending more than $12,000 a year.
Right. So it's more payroll taxes for employers because it's taxable both for income tax purposes and for FICA and FUTA.
Because by the Affordable Care Act, ACA, employers have to offer minimum value, minimum essential coverage. So there's a base level plan that you have to pay for, or you're not compliant with the law. You have to make it affordable for your employees, which means you can only charge your employees so much. Those future increases are going to come out of the pocket of the employer. So that kind of leads us into your big case. I call it the big show.
The big show.
So why don't you give us a little bit of background? Why is this important, this particular case? Because when you first mentioned to me, we're challenging the ACA. Anybody that's watching this right now, they're probably thinking to themselves, ACA's been challenged a number of times. Nobody has
especially in Texas.
Especially in Texas. Nobody's had any success. And it really, you have to look at, okay, what specifically is somebody challenging? So can you give us a little bit, first of all, tell us why this would be important for a business owner, CFO, CEO, HR leader. Why is this case important to them? Why is it important to you?
So those are two different questions.
Two different questions.
Yeah. It's the employer answer takes a little bit to get to. And it is actually not necessarily the reason I got really involved in this. So, but the employer answer is this. The employer mandate is enforced through a tax.
And what is the employer mandate?
So the employer mandate is a pedestrian term, a colloquial term for what in the Internal Revenue Code is called an employer shared responsibility payment or payment excise tax.
So I own a business.
Right.
What does that mean to me?
So if you have 50 employees, 50 full-time equivalents, which is itself a kind of a complicated definition, but if you add up all your employees' hours and divide it by a certain number and whatnot, you get full-time equivalent employees.
So if I've got 50, so I have 50 full-time equivalent employees.
Then you're subject to this tax, which you can avoid if you provide what's called minimum essential coverage, which is really at its core just preventive services. That's the baseline. You got to offer that. There's two forms of the tax. There's an A penalty and a B penalty. They're calculated differently, and so the B penalty is the one where if you just provide what are called MECs or minimum essential coverage plans, they're just preventive services and maybe some telehealth or something. You get out of one penalty but not the other, and so for each employee that goes to the exchange and gets subsidized coverage, you owe an employer shared responsibility ESRP excise tax. Basically, the deal that you make with the government is I'm going to provide really crappy coverage, and in exchange, I'll get out of a nuclear penalty, but I will pay, basically reimburse the government for some portion of the subsidy that it pays. The ESRP penalty does not equal at all what the government is spending in subsidies on the exchange, but it's punishing enough.
So an employer that's offering a traditional health insurance plan with one of the major carriers, and they're making it affordable.
Right.
So
there's that element as well.
So if they're affordable, then I'm not subject to any of those penalties.
Correct.
Then. Okay.
Yeah. So if your eligibility is defined in roughly the same way that this IRS tax defines a full-time employee, then yes, if you're offering health insurance to all of those folks who are deemed full-time by the IRS definition, then you can evade both the A penalty, which is the nuclear one, and then the B penalty. The A penalty is nuclear because it is times all full-time employees. So you're talking about roughly it's inflation adjusted. I think we're about $3,000 a year. For the A penalty. So it's 3,000 times all your full-time employees, right? If only one person goes to the exchange and gets a subsidy, then the nuclear penalty is 3,000 times all of your full-time employees.
So it's a very large number, and it's a tax penalty, not a tax deduction. Yeah,
right.
That's an important distinction.
Penalty. Non-deductible for business tax purposes. And in order to evade or get or not have to pay that penalty, you have to provide, good, relatively standard health insurance. It needs to be affordable according to these IRS definitions. Generally speaking, you're talking about an employee contribution of between about $115 and $150 a month or something like that
on the high end.
For employee only coverage, because it's pegged only to employee only, not the other coverage tiers. To 95% of those full-time employees, and then you can get out of both penalties.
So this ties in specifically to what your court challenge is.
So the tax penalties are only assessable if somebody goes to the exchange, gets a subsidy, and here's where the Department of Justice and I disagree, and the government has given you a notice that somebody has gone to the exchange, claimed they are eligible for this subsidized coverage, got subsidized coverage, or were preliminarily approved to get subsidized coverage, and you as the employer given an opportunity to appeal that determination. One of the things that makes you eligible is the presence or absence of an employer offer of good health insurance. Good meaning minimum value, so standard health insurance and affordable, right? So that's what we call good. And so you as the employer are supposed to have the ability to tell the exchange, largely in real time, that your employee was not actually eligible for subsidized coverage. Anybody can go to the exchange and get coverage, but eligibility for that subsidization, the public subsidy for that health insurance, is tied to whether or not you're offered workplace health insurance. And if you are, then you don't get the subsidy.
Right? And is that happening?
No, it's not. So let me get to the reason why employers should care. So as health insurance gets more and more expensive, it is going to be very, very tempting to re-examine who gets what types of health insurance. And if you've got a class of employees, and this is your typical, like white collar energy firm or engineering firm or
banks and financial institutions.
Banks, financial institutions. The tremendous competition for talent, right? And so you're not going to be, mainly full-time employees, maybe a few hourly folks in the mix. They're probably not going to change much of anything because their primary incentive is attracting and retaining talent, right? But your lower wage or higher turnover industries are looking at, when there's a narrower margin on your business, you got to find, it's one of the reasons why health insurance is why it's necessary to have a brilliant consultant working with you on your health insurance. Is because those costs are tremendous. And in a low margin business, think janitorial services,
manufacturing, distribution,
yep.
home health, assisted living.
Yep. Assisted living, nurse staffing. So even in the hospital context, you've got a lot of third-party companies that are supplying nurses and other professionals. That tends to be a low-margin business, even though the individual employee is very well trained, excellent nurse, makes a good amount of money. For the business, it's a low-margin business, yeah. Right? So in your lower-margin businesses, those health insurance costs are a big element. And so it is tempting to look at, okay, where can we kind of trim back a bit? Like if we've got a high turnover business, can we, what if we set our eligibility at 120 days or 6 months or something like that? Like you get something small initially, but if you want the big health insurance, you gotta stick around, right? So all kinds of ways to be creative about your eligibility that are presently not permitted, because if you don't provide the good health insurance to all your people deemed full-time by the IRS, then there's this big penalty, especially if the people you miss is more than 5%, you hit the nuclear penalty.
Yeah.
Hundreds of thousands, if not millions of dollars in taxes.
So what specifically is this case challenging?
So the Congress was tremendously concerned with due process. We've got this new public marketplace for health insurance.
Is this the healthcare.gov?
Healthcare.gov, right? You got this new thing, and you got these massive subsidies that are going to be paid to folks who don't have workplace health insurance. And generally Republicans, but it wasn't exclusively Republicans, were very concerned about either people fraudulently getting subsidies or just, it's crazy complicated. I don't know. So when I was, a solo lawyer, the ACA had been passed, and we went to the exchange and got coverage on the exchange. My daughter's care after her, so the birth and then her care right after she was born was on an exchange policy. I think it was a UHC product, Compass or something like that. Anyway, but it was an exchange product. So that process of applying for health insurance on the exchange, I'm an ERISA attorney, and it was challenging, right? So imagine, regular folk trying to apply for it. And so Congress was concerned that the process would be too complicated and that people would be getting subsidies who really weren't eligible for it. And so it designed in the law that was passed in 2010, kind of a two-part due process, one for the employee and one for the employer. So the employee goes to the exchange, applies for subsidized coverage. Open enrollment on the exchange is very similar to employer open enrollment in that it takes place in fourth quarter for 1/1 starting health insurance. So in government terms, that's really fast, right? And so a government agency has to evaluate an individual's eligibility and turn it around pretty fast. One of the things that Congress did in the ACA that was not so bright was it tied these subsidies and the specific amount to your personal income. in the year in which you get the coverage. So yes, the amount of the subsidy is actually finally determined based on your income from the year in which you actually have the coverage. So timeline, you go to the exchange, and when you go to the exchange, let's say it's as early as possible. It's like November 1st. Okay. So in November 1st of 24, which just passed, right? So in November 1st of 24, I go to the exchange to apply for coverage. It's based in part on my income. Okay. So I certify, no, I don't have any health insurance from my workplace and blah, 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 blah. But then it gets to the income section. So what do? You bring your tax return, not for 2024, because when's that due?
Next year.
April 25. So you bring your 2023 income tax return to the exchange, or they grab it from IRS rather, and they evaluate that, kind of do a preliminary determination of your eligibility based on 2023 income, way in the past, for your 2025 coverage. So 2025 comes, there's no true up during 2025 because it's based on your income in 2025.
So it happened in April of 26.
April of 26. So on a 23 income tax return, you're getting a preliminary determination for subsidy eligibility for a tax return you're not going to file until 2026, right? That's kind of boneheaded, but that is the law. So be it. But Congress was really concerned about the due process here, presumably in full knowledge of this crazy long process. But people need coverage, and they need it now, right? Or in a couple of months. And so I said, okay, two things need to happen. One, the employee, if they get denied, they need to have an appeal right. That sounds like good governance to me, right?
Yeah.
You notice and appeal. It's kind of what we do here in this country. Similarly, if the employee says, I have no workplace health insurance, and thus is eligible, the employer is supposed to get, and this is in the law that Congress passed in 2010, that says the employer is supposed to get a notice that the employee went to the exchange and has been preliminarily determined to get a subsidy. What say you, employer?
Yeah, this would be where they say, no, we offered them affordable coverage. They're not eligible.
Correct. Right.
Does that happen?
No. So it doesn't. It happened in 2015. I'll have to go look that up, but I think it's 2015. HHS did this process in 2015 for a couple 100,000 employees worth, right? There are 300, almost 50 million Americans, okay? So, a couple 100,000 employees is not a lot of people. So they trialed this process in like 2015. Couldn't get it up and running in 2014. Trialed it in 2015, sent a couple 100,000 notices out to employers. Being in practice at the time, a couple of my clients got these, so I know what they look like. And it's a typical government notice with an opportunity for appeal. And so we did. We stood up for a couple of our large employer clients, a process of receiving these, getting the reports out of HR. Are they actually full-time, or do we care about this person getting subsidized coverage because they're part-time according to the IRS definition? Who cares? Like, we're not penalized for that. Did we offer coverage? Was it timely? We don't even offer crap coverage, so it should be good, right? Evaluate it and respond back to the government. And he had to do it pretty quick. He only got like 14-day turnaround or something like that. And then HHS was supposed to do something back. It never did. Not one of my clients ever got something back from HHS if they appealed one of these things. Nor do any of these clients know what happened to the employees' subsidized coverage. Like, we have no idea, right?
Okay.
We just got this notice, and it was only a couple 100,000.
So why is all that important?
Well, because the way that Congress wrote the tax, it says that a few things are supposed to happen. This is both the A, the nuclear penalty, and B, the tack hammer or individual employee-by-employee penalty. Both of them have the same language. And it says that in order to be penalized, not only do the facts have to be true, that is, the employee got subsidized exchange. Mind you, the law does not say that the employee was eligible. What it says, the penalty statute says, someone got subsidized exchange, whether it was lawful or not, right? They got it, and Part 2, the employer received what the law calls a Section 1411 certification. Now, what the heck is that? Section 1411 refers to that section of the ACA. So if you go to Section 1411 of the ACA and read it, it provides for this two-part due process that I told you about. A good portion of it is the employee portion, and then there's another part where employers are supposed to get some notice and an opportunity to appeal. And there's pretty clear requirements about the opportunity to present evidence. I mean, like it's pretty detailed. For Congress, that's pretty darn detailed. And so the penalty is contingent on an employer having received what's called a Section 1411 certification. And none of them have ever been issued.
So basically what you're saying is you're challenging the lack of due process provided for employers to dispute a penalty.
Right.
And what is the implication of that?
So the implications are really twofold, and I'll get kind of abstract and academic on you here for just a little bit, but this is important. So we are a nation of laws, and it is woven into the fabric of this country. If you read the Federalist Papers, if you watch the musical Hamilton, you'll get an idea that we are a nation of laws. And going all the way back to childhood and Schoolhouse Rock, we are taught as children that Congress passes a law, the president signs it. So Congress passes a bill, right? President signs it. It becomes law, and that is the law. And then judges interpret the law, right? Mm-hmm. That's the three branches of government, shared powers, right? What happened in this case is that Congress wrote a law, and it said there's this two-part due process, one of which involves a certification going to the employer that should have happened. So this is what's supposed to happen. Congress passed that bill, the president signed that bill, and then an administrative agency said, that's too hard. I'm just not going to do it. Okay, no big deal. Administrative agencies, a little bit of background, are part of the executive branch. Okay, so they're underneath the president. Okay, that's that branch of government. They do, over history, the administrative agencies have tended to operate on their own, so they're sometimes called the fourth branch of government, but it is, in our Constitution, in the executive branch. So it is permissible for the executive to say, you know what, I'm just not going to enforce that law. Happens all the time, right? Think of it like prosecutorial discretion. Yeah. The law says that this is a crime, but I'm just, you know what, like, I don't think that's right. So the prosecutor says, I'm not going to prosecute. Like, that's okay. It is up to the executive to choose whether or not to prosecute. But that's not what HHS did. What HHS did was it said, I know Congress wrote this due process. I'm just not going to do that part.
But I'm going to enforce it.
And so HHS passed a regulation, it issued a regulation, finalized it, that said, IRS, you continue to penalize. I mean, gave orders essentially to IRS to penalize employers anyway. And so IRS went along with this scheme. And when it sends these penalty notices to employers, there's a little footnote at the bottom that says, this is your Section 1411 certification. So the IRS, instead of this notice being given during the exchange application process, it's happening when the IRS sends you basically a bill, right? It gives you an opportunity to dispute the bill a little bit, like, oh, no, I did offer health insurance or whatever, but there's no real-time process. True story, it takes currently IRS almost 3 years to get employers notice of who went to the exchange, got subsidies, and therefore you owe a penalty, right? 3 years after the fact for a process that HHS was supposed to implement in real time. So in my example earlier, in November, maybe December, maybe January if they're moving slow, okay, fine, but not 3 years later. And I noticed this immediately when these notices weren't coming and people started getting penalty letters. I'm like, wait a minute, hold on a second. Like, where's this certification? Like, the law actually says this is an element of that the government has to prove, right? This is an element of the tax. Where is it? What's going on? And the agencies just kept marching on. Couldn't challenge it. And it's important because we are a nation of laws. And when an administrative agency says, I'm not going to do due process. Forget about, I'm not going to, check some box on some form or whatever. Okay, fine, whatever. But this is due process.
And it's a big deal.
It's a big deal. Like, I'm not going to do this and I'm going to penalize people at the same time. how in this country does that continue? How does that exist? How is that a thing? And I learned real quick why it was really hard for anybody to challenge. There's another law that makes a lot of sense once you think about it. It basically says you have to pay a tax before you can challenge it.
Okay.
And that makes sense. If you and I could avoid income taxes for years just by saying, you know, oh, I want to challenge this rule or whatever and wait for the federal court system to work itself out, and by then I've died or whatever, right?
Makes sense.
Okay, cool. The federal government needs its revenue, so you pay the federal government, and then you can chase the refund, essentially. Like, so you pay the tax, you claim a refund, and then you can litigate over it. Well, so the businesses we're talking about are generally low margin businesses. So, you know, among the list that we mentioned, you know, janitorial, bar staffing companies.
Mm-hmm.
So, you know, airport services of any kind, generally pretty low wage and low margin, healthcare, et cetera, right? If you're a medium-sized business, you've got 100 employees or so, and you're running it, it's pretty low margin, and you get a tax bill for $300,000 that you have to pay first and then go collect.
They don't have an appetite to challenge it.
They don't have an appetite
or a
to challenge
budget
it.
probably.
They don't have a budget or I mean, like, you know, some of the companies that we had talked to about this, like, hey, this needs to be challenged. They either said, you know what, I've got a government contract and I don't want to jeopardize that. Okay, I kind of get that. Two different departments and they don't communicate, but okay, I mean, I kind of get that. A lot of them went out of business. They don't exist. They're gone.
Do you attribute that partly to the penalties?
Yes. Yeah.
Okay.
So
we're talking big. We're talking. This is not table stakes.
Nuclear.
This is big.
Yeah, it's nuclear, and so nobody could challenge it. Also, the process of actually challenging a tax statute is incredibly complicated, and you have to go through this Byzantine maze that the IRS has before you can ever go to court. If you go to court before going through the Byzantine maze, your case gets tossed. And there were a couple that were filed on this very issue a few years ago, and all of them got tossed because nobody went through the maze.
So it sounds like to me like you have a client that wanted to go through the maze and challenge.
Yeah. So they could stomach the loss. We figured out how to not make it so nuclear. So my firm figured out how the appeals process worked. We got to know some of the people in the IRS Service Center and the appeals unit, and we knew we had to pay one to get the issue into court, but we also figured out that we could probably keep the others up in the air in this, like, keep it in the Byzantine maze, right? And therefore make it viable for the client to do something about. You know, and I made the same pitch that I'm essentially making here, that, like, this is an issue of fundamental fairness and rule of law. And the client, Tony Falk, his name's on the petition, believed in the cause as well. That this is not how our country operates. This is not how it should operate. I'm actually a big believer in the ACA. We are probably of different political persuasions.
And that's okay. I mean,
totally. Yeah.
There's probably more that we align on. And I think this goes for all Americans, regardless of your political affiliation or your political beliefs. If you just think about what we're all trying to accomplish, what our goals are, I think there's a lot more alignment. The media is really good. Yeah, the media is really good at dividing us on particular issues. But I think just about anybody that I come in contact with on a day-to-day basis, regardless of what their political affiliation is, I think if we notice more of this, the commonalities that we have, those are greater than our differences.
Yeah.
We may have a difference of opinion on what's the best way to accomplish a shared goal,
Concur.
but everybody has shared goals.
Yeah.
We all want the same things. We just may differ on how. What's the right approach to achieve those?
It was a hard thing to do for me because, for a number of reasons. One, I believe in the public policy of the ACA. Its execution was not the best, but I believe in the public policy of the ACA. And it's been an issue in my family for quite some time. My uncle actually was the chair of the U.S. Preventive Services Task Force for a number of years. Health policy was something we debated as a family at Thanksgiving dinner. For years, leading up to and after the ACA was passed. And then when Dr. LeFevre, Mike LeFevre, sat on the U.S. Preventive Services Task Force, we debated it still. And so, like, the health policy is I don't know, kind of like my family's pastime. And to attack it was a difficult thing. But at the end of the day, this is where the commonality comes in. The commonality is that we are a nation of laws. Like, rule of law is what we live by. It's what keeps this country together. And a system of common rules that we all decide to follow. And here we have an administrative agency, two of them, HHS and IRS, that have opted not to and to do their own thing. And now you've gone off the rails. And public policy of the ACA aside, we now have a much more fundamental problem. And so we took up the charge.
Took up the charge. Okay. And so if you're successful, what would you predict the outcome to be? And what would be its impact?
So HHS could stand up the process, right? They're not going to, but they could. They could dedicate the people power to do this employer appeals process. It is very labor intensive.
But that's not what's going to be decided in court.
So no, what's going to happen in court is, and I have all confidence that we will win this. It's going to be a difficult road to hoe. DOJ is going to throw everything at us. We've had our first round of motions where the government said we need to dismiss this case outright, and here's why. And we've responded. And in the course of doing that response, I'm more convinced than ever that we are going to win this. So at some point in 2025, probably it may get over into 26, but I think it'll be 2025. We'll probably get a ruling that says that these ESRPs, the employer shared responsibility payment excise taxes, cannot be assessed unless and until this due process we talked about is executed upon, is created and executed upon.
So let me make sure I understand what you're saying. The penalties cannot be enforced.
Right.
So essentially you're talking about the employer mandate.
The employer mandate goes away. Yeah. The employer mandate goes away.
Unless HHS can stand up a process, which they've not been able to do since 2015.
And they're not going to.
And they're not going to.
Right.
So essentially you just gutted
half of the ACA.
Half the ACA.
Yeah, the employer mandate goes away.
This isn't going to affect insurance companies.
So
necessarily,
indirectly. It will indirectly. It's not going to do anything about the medical loss ratio law. It's not going to do anything about most of your market reforms. So the requirement that you basically cover anything and everything.
Yeah, pre-existing conditions, unlimited amounts, mental health parity.
None of that's
going to stay the same.
Yeah, that all stays the same. What's different is that there's no mandate. There's no employer mandate, meaning your lower margin businesses can go back to pre-ACA days. And you can go back to management carve-outs and things like that. You got some tax issues with Section 125 and whatnot. We can debate that another time, but it becomes pre-ACA as far as that's concerned.
So if all of that is true, this is my biggest prediction. If the employer mandate goes away, what you're going to see is a hyper-customization of insurance by employers that have the ability to do so. And those are going to be employers that have partially self-funded or self-funded health insurance plans, because employers are the insurance company. They can design whatever coverage they want. So you think about those low margin businesses, you have somebody that's making $15, $20 an hour. They can't, even at the affordable levels, they're not able to afford it.
Right.
They're not able to afford coverage. And so it's going to give the employers an ability to design coverage that meets the workers where they are, that can be designed to be affordable for the employee and the company.
Yeah, you're still going to have your stratification of your, what some folks at IRS have colloquially called shit mechs, your crappy insurance, right? The preventive services stuff, and you're going to have regular health insurance, because the market reforms are not going to go away. But what it does allow the employer to do is to decide with more granularity who gets what kind of coverage.
Yeah.
And we're just not going to offer, because it's no longer subject to the penalty, right? So we can, yes, provide different types of coverage to different types of people, so long as you comply with some non-discrimination rules and whatnot, that basically says you're not supposed to have a self-insured management carve-out, like that kind of thing.
But if there's no affordability testing, okay, so follow me here.
Oh yeah, right.
No affordability testing. I have 3 plans that people can pick from: a good, better, best. All employees get to pick from all three of these plans. One has a $0 price point. There may be limitations. It has gene therapy carve-outs. Maybe it doesn't cover specialty medications. Maybe there's a limitation. It doesn't comply with mental health parity, whatever it is, right? But if you look at how people use health insurance, and I'm not advocating for this, I just know my thoughts on where a market's going to go.
Yep. People are rational.
People are rational. If I look at the utilization of a health insurance plan, what is everybody using? How do they use it? Design a plan that covers that. And not because a lot of insurance rating is based on risk, and they're looking at actuarial tables. If I have 1,000 employees, how many of them are going to need transplants? How many of them are going to have a preemie baby? How many of them are going to need gene therapy? We may not have any of that inside of the plan today, but we're going to rate for that because it's just a matter of time. It's probability. It's law of averages, right? It's going to happen at some point. But you can design a plan that limits risk to a reinsurer, and it also limits risk to an employer. And you can offer plans that cover everything, and you can put them side by side. It's kind of a difference between, or a middle ground between MEC that doesn't cover anything all the way up to fully compliant ACA plan. You can design a plan that meets the masses where they are.
And that top tier plan, right, in your spectrum, the top tier plan does not need to be $100 a month, right?
That's right.
Because affordability
Based
is
off the
only
lows.
enforced through employer shared responsibility excise taxes. It's not a market reform. So employers across the board, this does affect your white collar firms, right? They can now charge more because they don't have to be worried about the employer shared responsibility excise tax anymore.
Yeah, they just have to worry about competition in the marketplace for talent.
They just have to worry about competition for talent, right? And so this kind of automatic drive for most firms to do the basically federal poverty level safe harbor of like $115 or so a month. You don't need to do that. All of your plan tiers can be whatever it is that you, as a business, can set your contributions at. So it opens up the possibilities on contribution structure.
This is why I think it's going to create if this is in fact successful, I think you're going to see a seismic shift because you're going to change the risk profile for employers when it comes to meeting affordability. So as inflation continues to rise, you're going to see two things. You're going to see employers being able to charge differing amounts to their employees, whereas they have limitations today. And you're going to see a shift, in my opinion, particularly in those mid-margin, low-margin businesses where they're now going to have an outlet to go to custom design plans, which is going to shift business away from traditional carriers even further. I think you're seeing this mass shift right now, at least in the mid-market space, where employers have said, we've had enough of dealing with the BUCA carriers, the traditional insurance companies. We're going to take matters into our own hands because solutions have been out there for, the company that solved healthcare was a book that was written pre-ACA. And if you look at the roadmap that company was a mid-market business CEO that wrote this book, the strategies that he was using back in 2007, 2008, 2009, pre-ACA, the book was published in 2009, 2010. It's modified, but still working today. So a lot of people are looking to the government to solve the problem. The solutions are actually at the employer level if they opt to take a different approach. And I think you're going to see an acceleration of that.
If the inverse Cadillac tax thing doesn't happen.
Well, if that happens, it's going to accelerate it even further. You're just going to throw fuel on an already burning fire because think about what they're doing is what incentive
they're now paying they're paying payroll tax on top of
that's right. So what's the incentive of an employer now is to figure out how to get the value, how to decrease the cost per employee per year.
Everything above 12,000 becomes
right.
So automatic 7% increase.
So if I can take something that's $14,000 per employee per year, I'm not going to pay tax on $2,000, right? If I can take that $14,000 per employee per year and I can now reduce it to $9,000 per employee per year, it's fully tax deductible.
Fuel on the fire.
It's going to exacerbate the problem or the potential solution. I'm not going to say whether it's good or bad. I think it's actually both. I think it's both because employers that don't want a unique strategy like that, they're going to be able to continue doing exactly what they've been doing today. But employers that are hurting, where you talked about a tax penalty putting a company out of business or rising health insurance costs, compressing a margin where they can no longer expand or compete, threatening the viability of their business, we see that. They're now going to have a way to meet the employees where they are, provide them a benefit without being subject to those penalties. It's going to open up it's going to unlock a whole different level of creativity to be able to provide true benefit to people, in my opinion. Yeah. Because today what we see this all the time, particularly in those low margin businesses, you see so many people that don't opt to buy health insurance. Why? Because they can't afford it.
Right.
And who does that benefit? Everybody needs affordable health care.
Yeah.
And that can be when they forego the insurance. And if it's offered compliantly today, they're not eligible for a subsidy on the exchange. So what happens? They go without insurance altogether. I don't think that's good for society.
Oh, you touched on an interesting issue. Okay, so let's game this out. So employers are no longer worried about the employer mandate, both affordability and eligibility, right? So they're no longer worried about that. Let's say, they tighten up eligibility a little bit, make the contributions, let's say technically unaffordable, but still, health insurance is really expensive. So something that's like $150 or $200 a month, it's still a decent deal when you're getting so much benefit as an employee.
Relatively, it's a decent deal, but for the average person, it's not.
Right. So let's say that employers decide, okay, I'm going to raise my employee contribution a bit and go ahead and exceed the FPL safe harbor or the whatever safe harbor you're using, right? Because it no longer matters. Those folks who say, look, I can't do $200 a month. They can go to the exchange and they get subsidized coverage, and the employer's not penalized for it.
Okay. That makes sense. Let's go on the other end of the spectrum, though. For an employer that says, because what do you get on the exchange? David, we look at these plans, right? $6,000 deductible, $8,000 out of pocket. But I think there's an important distinction to make between the cost of the insurance and the cost that people have to pay when they go get care.
The out of pocket.
And most of the affordable plans are going to be ones that are high deductible with no copay, and that prevents a barrier for the average American to be able to go get care when they need it. So I think about this from a coverage standpoint. If you look at how most people use health insurance, the 80-20, right, or 90-10 in health insurance, it's a very small percentage of the population that has catastrophic claims that needs really intensive care or expensive care.
Right.
The way most people are using health insurance plans is they're going to go to the doctor for a sick visit. They're going to take a basic medication. They might need a surgical procedure. They might need an inpatient hospital stay, but it's not going to be big, right? It's not going to be I'm in ICU for 6 months, or I need to take a gene therapy. It's not that type of utilization. How do people use health insurance on a day-to-day basis? Designing a plan that meets those folks where they are, what they need, that they can afford, and they can afford to use it when they need it. And it also has a catastrophic component to it. If I am involved in a car accident, I am in an ICU for 30 days, it covers that. There's a way to marry all of it together where you can take an employee that makes $15 to $20 an hour, and an employer can actually offer them an affordable plan that they can afford to use. But they can't. It's really hard to do that today in an ACA world where I have to cover unlimited everything, soup to nuts, specialty medications and gene therapies and all of these things, and there's no sorts of limitations, because ultimately what employers are ending up doing is they're paying for somebody else's coverage that's using that because the carrier they're using is paying for somebody else to use it. So it's all baked into their rates.
Yeah.
I think there's a way to kind of marry the best of both. That's probably a separate conversation. So to wrap this up, closing thoughts. What do you think is going to happen?
So it's going to take a few years for people to figure out what the implications really are. But ultimately, I think one, there's going to be a reckoning on the employer mandate. Oh, by the way, so in the course of preparing this brief that in response to the government's motion to dismiss, we did some further research, and get this. So we found another post-ACA law about Section 1411. I didn't know it existed until we did some further research. In October of 2013, Congress passed an appropriations bill, signed into law, for 2014. And there's this little paragraph in there that says that HHS shall not issue subsidies on the exchange until it has certified to Congress that it has stood up the due process required under Section 1411.
And that's in the law?
That's the law.
So it seems like that's just a complete breach.
Yeah. So Congress passes a law in 2010, says this is what you're supposed to do. They also, in that law, command HHS to do a study and report back to Congress on due process, which it didn't do. And then in 2013, in a 2014 appropriations bill, again said, not just you can't penalize employers, you're not supposed to be giving out subsidies on the exchange until you've certified to Congress that you've followed the due process required in Section 1411. And there's both employee and employer parts of that section, right? We've done some initial research into the congressional record. We've not found any such certification. We'll find out. It may exist, but I mean,
Wow.
If it doesn't exist, that means that every dollar of subsidy that's been given since January 1st of 2014 has been unlawful.
So what is that going to mean
Billions.
for what is that going to mean for employer? Somebody that's watching this that says, "Well, I was penalized and I paid my penalty."
Yeah. So yes, you're talking about the ability to get refunds, and they'll need a little help doing it. But once the judge makes clear like what the law is, then those procedures will be clearer. But yeah, it means that anybody who's paid a penalty should be able to go get a refund. There are time limits on the refund. And so we'll have to see what the courts do. There is some precedent for the U.S. Supreme Court to basically put a time limit on it. This was same-sex marriage decision. The part that only us tax geeks cared about was like toward the back of the opinion. The Supreme Court said, hey, we're going to let people go get refunds, but only for a certain amount of time. In other words, we're not going to bankrupt the United States of America any further than it already is with this judicial decision, which was smart on Justice Roberts' part. So they may do the same thing again. I don't know. Who knows?
Okay.
But yeah, you're talking about refunds if anybody's paid it. And you're talking about like a new conversation at renewal time. You're talking about like, do we really need to keep our eligibility the way that it is?
Yeah.
Do we need to keep our waiting period the way that it is, which is an interesting question. Do we need to keep, what does our contribution structure look like? All of a sudden it's a new conversation. And on the margins, I think you're going to see the low margin businesses say, I'm out of this. I'm going to go back to what I was doing in 2009. You're going to have, and then over a few years, you're going to have larger and larger employers going, let's rethink this a little bit. This is a runaway freight train of costs. We got to do something. So pull all the levers. And then it's our prognostication about, what employers are going to respond to and whatnot, how the incentives align. So we'll have to see.
Okay.
It'll be interesting.
Awesome. Well, I appreciate you sharing all that with us. I know it was detailed, long conversation, but as we can tell just by your closing thoughts, this is going to have some pretty big implications, both by financially and benefit design and operationally from an HR leader standpoint. You just mentioned a handful of really important ones that they cause some pretty significant headaches operationally for folks that are operating benefit plans. So thank you very much. I appreciate you taking the time with us, and we look forward to seeing how the case pans out.
We'll keep you posted.
And I don't know, dare I say, fallout from it. So.
We'll see.
Yeah.
Just holding government accountable.
All right. Thanks, David.
You bet.